Ballantyne, a partner at Madgwicks Lawyers. With our ageing population, will disputes are unfortunately on the rise. We're seeing this all the time. These are stressful and emotionally charged for everybody involved. While the process of contesting a will can vary on the specific circumstances of each case, there are several common legal issues that arise in these types of disputes. So, the grounds for contesting a will in Victoria include lack of testamentary capacity. If the deceased did not have the mental capacity to understand the nature and effect of making a will, the will might be contested. Secondly, undue influence. If the deceased was influenced or coerced into making a will that did not reflect their true intentions, again, the will may be contested. The third is improper execution. If the will was not executed in accordance with the formal requirements. And the fourth, which is one of the most common, is the family provisions claim. Family members or dependents of the deceased may be entitled to contest a will if they were not adequately provided for in the will. So to challenge a will in Victoria, a person must first establish that they have standing to challenge the will. This means they must be a spouse, domestic partner, child or dependent of the deceased. Once standing is established, the person may then file an application with the Supreme Court of Victoria. One of the most common legal issues in relation to challenging a will is establishing the grounds for the challenge. This can be a complex process that involves gathering evidence, such as medical reports and witness statements, to support the claim. Another issue is the timing of the challenge. In Victoria, there is a strict time limit for challenging a will. An application must be filed with the court within 6 months of the grant of probate or letters of administration. If a will is challenged, the executor of the estate will need to defend the will. The executor's role is to ensure that the deceased's wishes are carried out in accordance with the will. To defend a will, an executor may need to gather evidence to support the validity of the will and demonstrate that the deceased had the testamentary capacity to make the will. Another legal issue in defending a will is potential for conflicts of interest. The executor of the estate may also be a beneficiary under the will, which potentially can create a conflict of interest. In these situations, it may be necessary to appoint an independent executor to administer the estate and, where necessary, defend the will. So what do you need to know? Contesting a will in Victoria can be a complex and emotional process that involves several legal issues. To challenge or defend a will, it is essential to seek legal advice from an experienced lawyer who can guide you through the legal process and help you understand your rights and obligations. I hope this was helpful. If you need any further information, please feel free to contact me. Thank you.